right, I think we're ready. Good morning, everyone. My name is Sipra Boyd, and I'm a shareholder with Roberts Markel Weinberg Butler Haley. Happy to see everyone and see everyone's names and a few faces this morning. Today, we're going to talk about the exciting world of 209 letters. This is basically a 101, a crash course into the 209 letter that is specifically for the collections process. So you've probably seen in our other webinars where we've talked about 209 letters that might also mean the deed restriction violation process, because there's also a letter that's required for compliance issues. And we're going to touch on a couple of those, I guess, requirements as it relates to compliance and the 209 letter for deed restrictions as we talk about the collection letter. But this is, again, specifically in reference to the collections process. So let's get started. Our typical disclaimer, the information that I'm going to talk about today is based on the law as it exists today, April 12th, 2022. And obviously this information is presented for educational purposes only and doesn't constitute legal advice. If you need specific legal advice as it relates to your association and the collections process, we encourage you to contact your association's attorney to ask those specific questions. The agenda for today, we're going to talk a little bit about the collection policy, the specifics as it relates to the 209 language in the Texas Property Code. So anytime I mention 209, I'm talking about Chapter 209 of the Texas Property Code. That's where the information that we're presenting today lives. It's what is applicable to all property owners associations or community associations that have mandatory membership. And that usually means you have a mandatory assessment that everyone's obligated to pay. And that's how you know that Chapter 209 applies to your association. We're also going to talk about payment plans, attorney's fees, and why that's the 209 letter is important as it relates to attorney's fees. And then the last two topics really have to do with why the collections 209 letter is important in the deed restriction realm. It has to do with the suspension of common area and the hearings process. So we'll dive right in. In terms of collection policies, it's really a big recommendation for us that the association consider the adoption of a collection policy. And why we highly recommend a collection policy is because it gives the membership, the homeowners, an understanding of how the collections process works. So, as it relates to most collection policies that we would recommend, there's a good explanation of how the assessments are collected and potentially what demand letters or notices that a homeowner will receive in that process. And in terms of homeowners that have this understanding and boards that are going to use this process, we like a collection policy because it provides a consistent process for the collection of assessments. As you have different boards that come in and out of homeowners associations, it's really encouraged to have some type of a policy in place so that homeowners know what to expect. Again, a collection policy is not necessarily required, but is highly recommended for all associations. In terms of what the policy should include, we recommend that it talks about specifically the due date of the assessments, and you'll find that information is in your declaration. It'll specifically say that the assessments are due typically by January 1 of the current year, and then they become delinquent after January 31, which means February 1st, there's either penalties or interest or late fees that will hit. Every association is different, so certainly work with the association's legal counsel in crafting this collection policy so that you have a good understanding of what the requirements as it relates to the assessments are. Some assessments for associations are due quarterly. Some associations might have a monthly assessment. that's more common in a townhome association, which is still a single family association. And it's also very common in condominium associations, but 209 does not apply to condominium associations. So we're talking about just single family associations where you have lots and blocks, and townhome associations, which you might have shared walls, but the townhome is owned exclusively by the homeowner, including the land underneath it. The policy should also include notice that the costs, including collection fees, interest, attorney's fees, and late fees, are collectible against the property. Now, that's a very specific, again, issue where you're going to have to rely on your legal counsel, your managing agent, to guide you through to have a good understanding of what the association can actually collect and what is secured by the association's lien. What's really important for property owners associations is that the assessments are often secured by a lien against the property. And you want to make sure that that is stated in the collection policy so that homeowners understand that the association has a right to potentially foreclose against the homeowner on that lot in order to recover its assessments. Oftentimes, additional amounts are also secured by the association's lien, specifically attorney's fees, other collection costs or fees, interest, late fees. So look for that exact language in your declaration to make sure you understand what is collectible by the association, which may or may not be different than what is secured by the association's lien. Sometimes the Texas Property Code gives the association the ability to assess late fees or interest, even if your documents are silent on that issue. But again, talk to your attorneys to make sure you are collecting what the association is authorized to collect and that your collection policy is specific and in relation to what that authority is. A general description of the number of letters that may be sent. The way that we typically draft our collection policies, and it's again in conjunction with the board and what the board thinks is appropriate for their particular community, is 1 or 2 courtesy notices that are sent typically after the assessment becomes due or delinquent, starting February 1st. And then obviously the final notice, which is what we're going to refer to as the 209 collection letter. And that's what, again, this presentation today is about. There's no requirement in the law that the association send more than a specific number of collection or courtesy letters. A lot of association board members or managers ask us, well, do we have to send a courtesy notice? Do we have to send 3 courtesy notices before we send that final collection notice, that 209 notice? And I will say this again a couple of times, but there is no requirement in the law that the association send a courtesy notice. Your documents might require some type of notice, so certainly check that. The only requirement in the law is that the association send a 209 collection notice, and we'll talk about why that is now the law and why that's important. But having that process and the number of letters that you may send, maybe not are obligated to send, is really an important part of that collection policy. Again, any indication of specific late fees or interest that is charged, you can either state in the collection policy that late fees or interest will be charged as authorized under the declaration, or if the declaration doesn't really set a particular amount for late fees, or it says something like the interest shall be the maximum amount allowed by law. The collection policy is a good way and really an appropriate way for the board to set the late fee amount, whether it's $10 a month or $25 each quarter, whatever that late fee is that you're going to attach to an assessment. The collection policy would be a great place for you to put that specific amount. And again, also interest. Maximum allowed by law is really an issue that we grapple with daily. A lot of associations and managing agents think that 18% is the maximum allowed by law, and there is really a question about that issue. And so you want to go ahead and set the proper interest rate in your collection policy, which again helps with consistency and letting homeowners know what to expect when their assessments are delinquent. One of the most important parts of a collection policy is that the payment plan schedule. By law, the association has to have a payment plan schedule, and a collection policy that generically kind of talks about the payment plan process is really a good place to put that payment plan schedule, which is again required by law. The association has to offer each homeowner at least 3 months, but not more than 18 months in terms of a payment plan when they send this 209 collection letter. What's important is that there are parameters around that payment plan schedule, and we'll get into a little bit about that later on in this presentation. But you have to make that schedule available, and the 209 collection letter has to point to that payment plan schedule when it is sent to the homeowner. There are lots of other things that the association can put in the collection policy, and this is really an area, again, which the board and the managing agent should work with its attorney on what is appropriate and what may be too much or what is too little. But really, more information oftentimes it is better to a certain degree. You don't want to always have to be updating your collection policy if there's a lot of information in there and if it's too specific. A provision relating to the homeowner's mailing address is really a good provision to have in there. Oftentimes, the collection policy will state that the notices will be sent to the homeowner's mailing address, and it'll be the last known mailing address that the association has on file for the homeowner. What's really important for the collection policy in connection with this specific provision is to put that the burden for updating the homeowner's address that the association has on file belongs to the homeowner. The association isn't obligated to maintain a current address if the homeowner doesn't notify the association that there's been a change. If the homeowner moves out but retains the property and has an offsite address, then it should be on the homeowner to update the association and let them know about this offsite mailing address. So the collection policy is a good place where that obligation can live and something that you can point to when a homeowner's upset that they didn't receive their notices at the right location. The association really, although it isn't obligated to check, let's say, the appraisal district to see if the homeowners changed their permanent mailing address. So again, here's some important parts of a collection policy. Obviously, there can be other provisions that are really important and necessary that could be incorporated. So again, work with your managing agent because sometimes they have fees that they're going to charge that might not necessarily be expressly stated in your declaration. It's a collection fee of some kind, but it's important for the managing agent to be involved in the conversation with your legal team so that we capture all these fees in that collection policy. In terms of adopting a collection policy, um, I hope everyone knows on this webinar that the property code was amended several years ago, and it requires that the adoption of a dedicatory instrument or an amendment to a dedicatory instrument, which is any governing document for the association, to occur in an open board meeting after proper notice. So let me just kind of flesh that out. Basically, how do we adopt a collection policy and what's the process? Well, first, you need to make sure that the board has authority to adopt a collection policy. And generally speaking, boards usually do. You can find that authority either in the governing documents, the declaration. There'll be a provision that says the board may adopt rules and regulations or policies or resolutions regarding um, the 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 subdivision, really any aspect of it, which could include a collection policy. That authority can also be in the bylaws of the association. So when you're bored one night and are having trouble sleeping, open up your board notebook and read all those fun governing documents, including the bylaws, and it'll tell you your duties under the bylaws, the powers that the board had. And oftentimes, one of those general board duties or powers is the ability to adopt rules and regulations. So look for that authority. And once you find that, know that once you work with your legal team to draft a collection policy, that there is a legal process that needs to be utilized in order to adopt the policy. Under Chapter 209 of the Texas Property Code, the board has to adopt that policy in an open meeting, in that open session. And so you need to make sure that that board meeting is properly noticed, which means that there needs to be notice to all the homeowners, whether that's by electronic notice, which is 72 hours or 144 hours before a meeting. And that depends on whether it's a regular meeting or a special meeting. um, whether the notice needs to be posted on the association's website and then also emailed to all the I'm sorry, all the homeowners. And then the other option is by regular mail notice, which is at least 10, but not more than 60 days before that meeting. So it needs to be properly noticed. There needs to be a quorum present at that board meeting in order for the board to act. And quorum is typically a majority of the board members. And then one of the agenda items in that open board meeting is going to be to adopt the association's collection policy or its payment plan policy. So make sure that board meeting is properly noticed, and that you use the proper process in order to adopt that collection policy. Always check with your legal team. Always read your governing documents to make sure that you're adopting that dedicatory instrument or that governing document in the correct process, because there are some nuances in all of your governing documents, and unless you really kind of dig down nitty gritty and read each and every word, you might miss something. So important to always check your documents. All right, so the heart of today's presentation is, what is this 209 collection letter that she keeps going on and on about, and why is it important? So, again, a few years ago, the Texas Property Code felt that the Texas Property Code was amended because the legislature felt it was important for a particular notice to be sent to all homeowners in the community before the association could go down the process of legally collecting its assessments. And the reason why it's important and required is that the association cannot, and so it's really important, that's underlined, scored, boldface, cannot collect attorney's fees or fees of a third party collection agent unless this 209 letter is sent. So, really important, because oftentimes, while associations are successful in collecting their assessments because there is a lien for those assessments, sometimes you're going to need to rely on legal counsel to collect those assessments. And when you do rely on legal counsel, there will be obviously attorney's fees that the association will incur as a result of sending out any demand letters and potentially pursuing the litigation process. And that means filing suit against the homeowner, or potentially foreclosing against the homeowner. All of those fees that the association incurs in going through that process are recoverable against the homeowner. And that obligation to reimburse the association for those attorney's fees or those third party collection agent fees are only authorized if the association sends this 209 letter, the 209 collection letter. For many years, and I touched on this at the beginning, associations were required to send 209 letters that are really related to the enforcement of a deed restriction or a compliance issue. This is a different letter. So let's dig into what is different about it. The 209 collection letter has to contain an itemization of the total amount due. So for all of you that are self-managed, or work with a managing agent, a management company, we work really closely with all of our management companies, and so they're aware of this law, but it needs to include an itemization. And that means if you have a balance forward of some kind because you have several years worth of assessments or interest or late fees, that's not going to comply with the 209 requirements under the Texas Property Code. It needs to break down each assessment year, each interest amount by year, each late fee by year. It needs to really provide an itemization of what that number is made up of. The 209 letter should be sent by certified mail. It needs to be sent by some verified mail process, whether, and we always recommend sending it by certified mail with return receipt requested. Oftentimes, a homeowner will not pick up their certified mail, and that's okay. What's really important is that we sent it by certified mail and that we can prove that it was sent by certified mail. We also encourage that the association send this letter by regular mail. And what that does is it ensures that the homeowner receives the mail. Even if the homeowner doesn't pick up their certified mail notice, we know that they received the itemization and the 209 letter, because the regular mail notice will be delivered. That is not a requirement under the law, but it's something that we highly recommend that the association does. The period to cure in a 209 collection letter is now 45 days. What does that mean? Prior to the 2021 legislative session, the period to cure in a 209 letter was 30 days. So the homeowner was given 30 days to either pay the amount due in full or contact the association and set up some type of a payment plan policy. For some reason, the legislature thought, well, 30 days is not enough time. We need to give the homeowners 15 more days. So now the homeowners have it. They've got 45 days. Make sure that you work closely with your managing agent to ensure that those 209 letters do now give 45 days to pay the amount due or enter into a payment plan. Next, the 209 letter has to provide payment plan options. It doesn't necessarily have to say you're entitled to a 3-month payment plan or an 18-month payment plan. But it does need to specifically say that the homeowner is entitled to request a payment plan pursuant to the association's payment plan policy or payment plan schedule. Now, if you have a set amount of months that you want to offer, surely you can include that specific language in the 209 letter, but it really needs to indicate that there is a policy or schedule in place that the homeowner is entitled to request. Attorney's fees, another really important provision or part of the 209 letter, is to make sure that the homeowner understands that if the homeowner does not either pay in full or elect to enter into a payment plan agreement under the association's payment plan policy, that the association will be incurring attorney's fees in collecting the amounts due, and that the homeowner is going to be obligated for the payment of the attorney's fees or for that third-party collection agent. The hearing, the common area usage, and the military notice, those last 3 bullet points are really only important and relevant and required if the association intends to suspend common area privileges. Now, we'll get into this a little bit more in detail in a few slides, but before the association suspends common area privileges, that means we're going to turn off your fob for the swimming pool for non-payment of assessments. Please, please, please make sure that the association has the right to do so. It is our position that if there is not a express right for the association to suspend common area privileges specifically for non-payment of assessments, that the association cannot do that. All right, so let's dig in a little bit deeper on a few of these items. I've already touched on itemization with the total amount due. That has to specify each delinquent amount and the total amount that is required to make the account current. So make sure it is an itemization and not a lump sum amount. Certified mail, again, we're not entitled to, the association cannot hold a homeowner liable for attorney's fees unless it sends this notice by certified mail. And it needs to provide written notice of all these important provisions before the association can do so. So make sure it's being sent certified mail. And again, with my caveat that I recommend it also be sent by regular mail. Finally, one of the most important changes that I know that we've seen a few a few associations struggle with here lately, because it's kind of on autopilot that the 209 letters have 30 days, is that the period to cure has changed from 30 days to 45 days. So before any further collection action can be taken, the homeowner has 45 days to cure the delinquency. We have some associations that kind of took some risks and said, well, we've already sent out our 209 letters and they all said 30 days. What do we do now? Our recommendation is to redo the 209 letters and give the homeowner 45 days. That's so frustrating, annoying, that obviously delays the collection process, because now we have to give them another 45 days. Well, why are we recommending that? It's because if a homeowner challenges the 209 collection letter and says it doesn't comply with the law, then the association is not going to be able to recover its attorney's fees. And that could be a big hit. If you have 50 delinquent accounts that you're considering sending over to the association's um, law firm, and the law firm sends out 50 demand letters, whatever the association's law firm charges for those demand letters could be subject to not being collectible because of that. And so you really need to make sure you think about the risks associated with moving forward. We do have some homeowners that are savvy enough to read that Texas property code and know whether or not the notice complies. It's out there in the world. There are lots of attorneys that more and more are starting to challenge that process, and so again, encourage you to work with your managing agent or whoever it is that's sending out your collection letters. If it's individual board members, or if you're self-managed, your on-site person, to make sure that that 209 letter complies with the law. The payment plan options, again, another important part. And if your 209 letter has all of the requisite provisions, but for whatever reason forgets to offer a payment plan, that's a big X. That means it doesn't comply. So you have to offer a payment plan to the homeowner for that assessment year. And it has to specifically say you're entitled to enter into a payment plan in order to avoid your account being turned over to a collection agent or the association's law firm for further collection. So very important provisions, and you need to make sure that the 209 letter complies. All right. In terms of what happens when the homeowner gets a letter, a demand letter, whether it's a courtesy notice or let's say they get a 209 collection letter that complies with the law, and they send in some type of a payment, whether it's payment in full or a partial payment. What do we do with it? I think that if you ask 10 different lawyers this question, you might get 10 different answers. So, this is really just one position. Um, there is a Texas Property Code provision, again, under Chapter 209, that requires any payment that is received by the association to be applied in a particular priority. And so you're on your screen, you're looking at that priority. If the association receives a payment and it applies it to the homeowner's account, and if it's a partial payment, it must first be applied to the delinquent assessments, then the current assessments, then any third-party collection cost or attorney's fees associated with the collection amount, any other attorney's fees, so that could mean attorney's fees in connection with a deed restriction matter, any fines assessed, which fines are always going to be low man on the totem pole. The legislature hates fines. And then finally, any other amounts owed to the association. So um, it's really important to make sure that your association is following the priority of payments application process under the Texas Property Code. We have heard from some associations and some management companies where the software, it's difficult to apply the payments according to the application of the policy, but that's what the law says, and that's what you have to do. A couple of caveats, obviously, always as it relates to the law. One, and this is really what I was talking about, you don't have to accept that partial payment. You can return that partial payment, which it's a double-edged sword. You've got money in your hand, so it seems like it would be appropriate to take that money and apply it and deposit that check while you get it, because as homeowners get farther deeper into debt, we know that it's harder for them to pay. So sometimes associations have to make that tough decision about whether or not to take it and apply it. But know that by applying it in the process and in the um, I guess the priority that is dictated by this provision, you might wipe out the entire assessment, right? So if you have a $300 assessment, but you have $200 in late fees, interest, and collection costs, and the homeowner sends in $300, once you apply the $300, you have to apply it to that delinquent or current assessment amount. And then you're left with late fees, interest, and collection costs, which are oftentimes harder to collect just alone. Sometimes those just kind of sit on the account until the next year, and associations fall into this difficult path of not being able to collect the total amount that they're out. And that's hard because some of those costs are hard costs. For example, collection costs that the association's managing agent might charge. So you really need to sit down with, again, your management team, the law firm that you work with, to talk about whether or not it's appropriate to accept that partial payment and actually apply it. Again, the other option is to return it and demand payment in full, or demand that the homeowner enter into a signed and executed payment plan policy that puts them on the hook for making payments towards that entire balance, not just the delinquent assessment. Finally, the other caveat that's important is that the association is not required to apply payments in that order if the homeowner became delinquent under a prior payment plan. So if a homeowner was given the opportunity to enter into a payment plan, but then defaulted on it the next year, the association's not obligated to apply any partial payments in this priority, except for fines. Fines can never be the first to be paid off. So just keep that in mind. One of the most important parts, again, for this 209 letter is the association's ability to collect attorney's fees. And again, I'll remind you guys, you can't collect attorney's fees if you don't send this 209 letter. And we know that attorney's fees are tough, right? I get it that they're expensive, and it's hard to, at the very least, be out attorney's fees and then wait for the homeowner to reimburse the association. So this is why this is really an important provision, and we want the association to be able to recover everything that it's out, hard costs, soft costs, including attorney's fees. And the reason why it's important is that the association, again, can't recover them if the 209 letter is not sent. Now, the reason why the association might need to include a hearing provision that gives the homeowner the right to request a hearing in a 209 collection letter is because the association is able to suspend common area usage for non-payment of assessments. And if that's true, then the association, again, in that instance, cannot recover attorney's fees unless it sends a 209 letter, and that 209 letter is different. The 209 collection letter is different than the 209 deed restriction letter. And this is kind of frustrating, and it's confusing. I will admit. I just think the legislature really kind of messed up on how this actually operates in the practical world. But in order to recover attorney's fees for assessments, if you're going to suspend privileges, you have to also give them a right to request a hearing. So let's walk through this. 209.008 says the association can only collect attorney's fees if it does take certain actions, but that the homeowner is not liable for attorney's fees until the association has sent this 209 notice and before the conclusion of the hearing under 209.007. And so we're going to talk about what 209.007 means, or if the homeowner does not timely request a hearing, and then obviously the homeowner's presence is not required to hold a hearing under 209.007, which we won't get too much into. But again, this really only applies if the association intends to suspend common area usage in response to non-payment of assessments. So where does this language come from? It comes from 209.006. Everyone's used to seeing this in connection with compliance issues. So if a homeowner doesn't seek approval for architectural control, if there is some type of a maintenance issue on the property, if they're parking junked cars. So typically under 209.006 for compliance issues, the association has to send a 209 notice. And that's what I'm talking about when I say 209 deed restriction notice, which is different from 209 collection notice. But why it's important, again, under this context, is if the association plans to suspend privileges to use a common area, then the association has to give this 209 notice. So let's talk about that real quickly because I don't want to confuse everybody. But the 209 hearing notice for deed restriction compliance issues or suspension says that you have a right to request a hearing in front of the board upon timely written request. The hearing that the homeowner is entitled to should be scheduled with the board not later than the 30th day after the board receives the request from the homeowner for the hearing. And the notification that is required to the homeowner for the hearing has to at least has to give them 10 days notice. So it needs to contain the date, the time, and the location for the hearing. And we won't have really time to get into the nitty gritty about the hearing, but the hearing requirements for the 209 hearing have changed under a compliance or a common area usage suspension issue. Now it's like a mini trial. So again, work with your legal team and your managing agent to understand what that means. This is in the small carve out instance when the association intends to cut off common area suspension or non-payment of delinquent assessments. I think most associations, well, I don't know the answer actually. There are several associations that don't bother with this because then you have to go down the process of giving a homeowner the right to request a hearing. If you don't end up cutting off common area usage for non-payment of assessments, even if you have the authority to do so, or if you don't have the authority to do so, then none of this really applies. You don't have to give this hearing notice. A lot of our associations still do. I will tell you that probably an account goes to a litigation and the judge has to talk to us about, what was done during the collections process. Even if you're not obligated to give the homeowner a right to request a hearing, it sometimes sounds nice that we did, and that the homeowner didn't elect to request the hearing. So I have associations, even though they're not suspending common area usage, they might still include the right to request a hearing. It gives again the association the ability to reach out a hand to the homeowner and give them one last opportunity to talk about the delinquency and find out, what might be going on with the homeowner and why they're not paying. Unfortunately, a lot of homeowners don't elect to talk to the board and they kind of just ignore notices, and that's when, we get involved. But I will tell you that at the end of the day, it does look nice in front of a judge to show that we've done everything that we can, including giving them the right to request a hearing. So it gets a little complicated when you're talking about non-payment of assessments and hearings, but if it's something that's just kind of an automatic process for the association to allow all homeowners to be given that right, then there's no harm in keeping it in that, keeping that the process the same way. In terms of the 209 hearing notice, if the homeowner does elect to request a hearing, know that one postponement is permitted. So they get an automatic 10-day extension. If the homeowner says, oh, I need more time, I've got some type of a conflict or just need more time. Obviously, additional postponements may be granted if the association agrees and the homeowner says it's just not working and we can't meet. I will tell you to be as flexible as possible as it relates to 209 hearings. Again, to show the judges we're bending over backwards. Yes, we get it. This is a $300 assessment, and yes, we might be trying to foreclose, but we're doing everything that we can to try and get this homeowner to pay. And at the end of the day, the association has its own expenses that it needs to pay and meet, and it can't do that if homeowners aren't paying their assessment. So it's a serious issue, and we're taking it seriously on both sides. We've got to march forward and try to recover our assessments, and the homeowner has to also talk to us and be willing to show up and explain why they may not be able to pay. Um, the one caveat that I'll say kind of over and over again is that the notice and the hearing provisions are not applicable if you're not suspending privileges. There's also one little gem in the Texas Property Code that gives the association the ability to suspend a person's right to use common areas if the suspension involved a significant and immediate risk of harm to others in the subdivision, and if it occurred in the common area. So oftentimes when this comes up, it's an incident that occurs either at the association's pool or the clubhouse. It could happen maybe by the entry gate into the subdivision if you have a gated subdivision. But if a homeowner does something that could be considered uh, or is involves a significant and immediate risk of harm to others in the subdivision, then the association can immediately suspend privileges. It doesn't have to be for non-payment of assessments. It doesn't have to be about some specific non-compliance issue. It's that immediate risk that triggers the suspension without notice and hearing. We're going to always still encourage you to give the homeowner the right to request a notice and the right to request a hearing through some type of a notice, but you can immediately suspend privileges. This is a really odd kind of provision, and we really use it in the most egregious of circumstances. Um, I had a situation where two homeowners were involved in some type of a spat in the pool. One of them threw a cell phone that potentially caused injury to one of the kids that was in and around the pool. It got, a little bit out of control. And that was an instance where we thought it's appropriate if we can identify the individuals involved to suspend, the aggravating homeowners common area privileges and keep them from the pool for whatever it is, 30 days or 45 days, until we can kind of get a hold of the situation. So it's again, work with your legal team on when you might be able to use it. It's not appropriate for all instances, but that notice and hearing provision won't apply in this instance. So you need to make sure that you're on solid footing before you suspend privileges of a unit owner. Okay, that's the bulk of my presentation. I know that I saw several questions come in through the chat during the presentation. Sorry I wasn't able to get to them during the presentation, but I'm going to see if I can go through them and answer them today. And certainly, if I don't get to your question, feel free to send them in, and we'll get some responses to you if you have some specific questions that I either didn't answer through the presentation or I wasn't able to get to. All right, so sorry, some issues with getting on. Okay, one question is a statement for revoking of access privileges needs to be in a 209, correct? And yes, that's kind of the last half of my presentation is if you're going to suspend common area usage, your 209 letter says we're suspending common area usage for non-payment of assessments. It needs to specifically be in there. The next question, we have a collection policy included in the declaration. If we adopt a collection policy, can there be any divergence? For instance, as Texas Property Code 209 changes or newfound challenges arrive, can the collection policy embellish the declaration? Is that a conflict? And you need to stipulate a hierarchy of documents. So it's a great question. If you have a collection policy in your declaration, that will control except to the extent that the law changes. And that's also a complicated analysis because sometimes even the Texas Property Code says, unless otherwise provided by your declaration, X. So even the law sometimes says you're bound by what your governing documents say to a certain extent. Um, so as it relates to Chapter 209, there's not that exception that says unless otherwise provided by your governing documents. So I think what's really important in the collection process is to make sure you're following what your declaration says and then tweaking anything that might need to be tweaked because the law has changed. For example, if your declaration says the homeowner should be given 30 days to pay, or 30 days notice before they can, or notice of their right to enter into a payment plan agreement. Now we have law that says they have to be given 45 days notice. So that needs to be in your collection policy, and that can be. And you can stipulate in that collection policy pursuant to Chapter 209.0063, whatever the provision is, the law now says you have to be given 45 days. You should never adopt a policy, board adopted policy or otherwise, that conflicts with the declaration unless the law has changed. So you can clarify, you can kind of explain the reason why, or define terms. One example I like to use is if your declaration says no temporary storage of vehicles on the driveway. Well, what does temporary mean? And temporary, if it's not defined in the declaration, the board adopted policy or rule and reg is a good way to define temporary. It might be, no more than 48 hours. So that's not necessarily a conflict. It's just kind of a clarification of what's in your declaration. But you should never adopt something that expressly conflicts with the declaration. So if your declaration says all fences must be 8 feet high and made of cedar, and there's really no exceptions, it doesn't give the board the ability to modify that by rules or regs or policies, then you can adopt a policy that says fences may be 10 feet and be made of wrought iron. So that's a direct conflict. So that's kind of a good description. In terms of hierarchy, I will say that your declaration is always going to be um, kind of higher in the priority than any board adopted rules and regulations. So the declaration is like what I like to say, it's like the Bible for the community. It kind of is what people bought into when they purchased the property, and that's what they should be able to rely on as you move forward. And you shouldn't be able to easily modify it, um, especially in conflict with the declaration by a board adopted policy. Now you can modify it through the amendment provision, which usually requires majority of the membership or 67% of the membership. But to the extent that a policy attempts to kind of modify express provisions, that's a no-no. And again, would encourage you to work with your legal team on that specific issue. A collection letter was sent via certified mail to a homeowner. The 45 days had not passed, and in the meantime, the homeowner sold and closed on the property. Can the HOA still collect the outstanding assessment penalties, etc.? Yeah, this is a specific question, and it kind of assumes that there's a lien on the property for all of the charges. Typically, there is one, at least for the assessments, if not all of them. But assuming that there is, then that lien follows that property. And even if there was a closing, now, unless the association messed up somehow and didn't provide a payoff at the closing or whatever, unless there's an error, then that lien attaches and the new owner should be liable for the amounts that are secured by the lien. And the old homeowner, quite frankly, is also personally obligated for those amounts. But our greatest our greatest leverage is that lien. And so you should go after, again, lots of caveats, talk to your legal team. You should go after the current owner, or really the property, which is now owned by a new owner, in order to recover those amounts. Can we do the itemization of the past due amount by putting in a detailed ledger as an attachment? Yes, we've seen that done so that you don't have to manually recreate ledgers. As long as there is an explanation, whether it's in an exhibit or attachment of that breakdown, then I'm good with that. It really is. Can you explain where this lump sum number came from? And if you can, in some type of an accounting that's attached, then that's perfectly okay. What if the prior management company didn't provide details of balances not collectible? Question mark. We say that they are potentially not collectible, and I'll tell you why. Um, One, as a third party collection agent or the law firm, we are on the hook, and potentially the management company is too, and also the association if the homeowner decides it wants to sue everybody for a violation of the Fair Debt Collection Practices Act. If that amount, that lump sum, includes amounts that are barred by the statute of limitations, or amounts that are not authorized under the declaration. So it's kind of a misrepresentation of the debt. So it's a very serious issue. And sometimes I think lots of people don't understand how serious it is. And I, you know, I, I think I'm aware of some management companies, some associations, some law firms that will send demand letters in that manner, with some type of a lump sum and not including an itemization. And guys, I'll just tell you, my law degree is much more valuable to me than that. And I just refuse to potentially, you know, uh, commit malpractice in order to collect an amount that I don't know what it's made up of. So I take this as a very serious issue, and you can be kind of um, I guess, clever with how you get that information, whether it's through your board members. They might have information about what those amounts are made up of. It might be through the law firm. If it's the same law firm, then that law firm might have ledgers that, from the prior management company that include breakdown. So there are other ways to get that information. So try and exhaust all your resources. And, while I'm on the webinar, I'll tell you guys, all you managing agents out there, if to the extent that you do have someone that fires you and switches management companies, I would encourage you guys to send over balance forward ledgers, because that really is a problem that's industry wide. And if you're not dealing with it now because you haven't had to, you'll eventually have to deal with it. And it's a complicated mess. So, everybody should play nice and try and give as much information as associations change management. Managing agents, we feel that way about law firms. It doesn't benefit the client to withhold information. So really encourage everyone to be fair and give the information that they need. Um, can we require payment by ACH only on a payment plan? Um, that's a good question. I think that the association can probably dictate how it accepts payment even under a payment plan. I don't want to make it extremely difficult for an association to get paid if the homeowner, for whatever reason, doesn't have the ability to set it up. And I'm thinking of those kind of least sophisticated consumers, like um, older people that potentially don't have assistance to help with setting that up, or even the means. Let's say they don't have access to internet, or whatever it is that they might need access to set up the ACH. So while you can require it, I would certainly talk to homeowners and be able to provide some other option if you can. About the common area usage suspension, we have a homeowner who is delinquent on assessments and will not receive a pool pass. However, the homeowner is on the swim team board and has a child on the swim team that uses our facilities, pool and community room. Can the HOA keep the homeowner and family from using the facilities as part of the swim team? The swim team is independent of the association. Ooh, that's a complicated question. I would say probably not. I know that that's a messy issue, but it seems like the right of access for the swim team child is through the swim team and not as a result of them living in the subdivision. So I really think that that would just be overly complicated. And if it's an independent organization, our rights may not, probably don't have anything to do with the swim team, even though the swim team has a right to access the facilities. It's not the swim team that should have to deal with that suspension issue. So that's really a messy question, and probably one that you need to talk with the law firm about in more detail. Just kind of on the basis of what you've asked, I would say that's a tough one, and I wouldn't recommend trying to keep the child from the facilities based on their participation in the swim team. Is the 209 45-day period just for delinquency of assessments, or does that include deed restrictions as well? It is only about collection of assessments. I will tell you, and I think I touched on this a little bit, associations are now, because it's too complicated to have 3 different versions of 209 letters, they're giving 45 days, whether it's the delinquency of an assessment, whether it's a common area suspension usage and a right to request a hearing, which is 30 days, whether it's a deed restriction violation, which is still 30 days. So the only thing that changed was collection of assessments. You still only have 30 days to request a hearing. You still only have 30 days to request a hearing for deed restriction violation notices. But if you don't want 3 different 209 letters, one that relates to delinquency of assessments, one with delinquency of assessments and common area suspension, one with deed restriction violations, then everybody just gives everyone 45 days, whether it's to pay your assessment, to correct a violation, to request a hearing. How much is a substantial amount to send over for collections? That one really depends. That's my favorite lawyer answer, which I know everyone hates, but even if you have a $200 annual assessment, everybody should know that you have a 4-year statute of limitations to collect assessments. So if your assessment year is older than 4 years that's due, then your law firm really can't collect that assessment or demand that assessment. So even if it's $200, while I might encourage you to wait a year or 2 before turning it over, if you're coming up to year 3, you're going to have to turn it over, and that's $400, potentially $600. Not a ton of money, but you're going to lose the ability to collect it if you don't do that. So that question really just kind of depends on not only the amount that's due, but how many years worth of assessments are potentially due. Can privileges be suspended for delinquent collection costs or just assessments? I'm going to say it should really just be for assessments. It depends on the language in your restrictions. It will typically say for non-payment of assessments, or sometimes I've seen restrictions that are more broad and they say for non-payment of any amount due to the association. So it might include late fees or interest or collection costs. I'm not a fan of if they're paying or they've paid the assessments, of suspending privileges for those administrative harder costs, but if it really depends on the restrictions and what the language is. If the separate policy and declaration must agree, then why is a separate policy recommended? So I always I like this question because the law is the law, and so a lot of associations want to know, why should we adopt a policy? It really is for uniformity and consistency purposes. If the declaration controls and it says 30 days, but the law says 45 days, if you don't have a board that has taken the time to kind of understand the law or is relying on its management team, they're going to move forward relying on the declaration and 30 days when it's incorrect. But when you have a policy and they know that they have to read all the documents, then they understand that it should be 45 days. So it gives easier access to the law. And the declaration, I think sometimes, if you think back to the developer in the beginning of a subdivision, it's really hard to amend a declaration, and there are several reasons for that. And it's because a developer, when it envisions a community, it wants to set up a particular aesthetic that the community should always be in harmony with. But it also should be something that is changeable with the time. So your community, that as it looks today is probably very different than it looked 30 years ago or 50 years ago when it was first developed by the developer. And in order to allow a community to change and grapple with issues that were never envisioned by the developer 30, 40 years ago, for example, short-term leasing or pods, those storage containers. No one ever thought that there would be big pods sitting on driveways. The law says that the board can adopt rules and regulations. It has some stipulations, and it's not necessarily a blanket authority, and it really depends on what your documents say, but you want to be able to make sure that you have the ability to kind of adopt and modify things as you see fit. All right, I'm going to take couple more, and then we're past our time, and we'll again cap it off. But send us your questions if you have any others, and we'll try to get them answered. If unpaid assessments are at year 3 and get turned over to the attorney for collections, does the statute of limitations reset? No, the only way to stop the statute of limitations is by filing suit. So it doesn't even stop when you turn it over for collections to the law firm. It doesn't stop when you send a demand letter. It doesn't stop when you file a lien, a notice of unpaid. The only thing that tolls the statute of limitations is filing suit. Yet another one on suspension of privileges. Can a homeowner who has privileges suspended be allowed to use the facilities as a guest of another homeowner who is not suspended? Our community allows 3 guest pools, back 3 guests per pool pass. Obviously the answer is no, should be no. They shouldn't be able to get around the suspension by saying that they're a guest, because they're not a guest, they're an owner. But the problem with that is enforcement. It's really hard to enforce things like that. And unless you have a good pool company that's really, willing to put their foot down and force a homeowner to not be able to access the pool, enforcement is a hard one. But, to answer your question kind of in a vacuum, they should not be able to get around the suspension by doing that. All right. Thank you all very much. We appreciate you guys for tuning in, and happy to provide these seminars to you. They're all located on our website, typically, not too long after the webinar. Look out for additional webinars coming up in the near future. And if we don't have your email for marketing purposes, please send it to us, and we'll put you on our distribution list for notice for future webinars. Thank you all very much, and have a great week.